this particular problem that I'm now quoting took place. They said that we have got very good doctors in UK, and one intensivist, a very famous intensivist, was flown in from UK to Bombay, and this intensivist who was brought into the picture by the patients saw the patient. By the patient's relatives saw the patient. The intensivist said, who came from UK, said, you directly disconnect the ventilator, we'll see what happens. And the ventilator was disconnected, and the patient suddenly arrested the moment the ventilator was disconnected. Now, this particular arrest was directly attributed to the decision taken by this particular doctor who was flown in by the relatives from UK. Now, will the hospital be accountable for such a negligent act that has taken place under its roof? If you read the Bolam's judgment, Lord Justice Jennings says no. Under the situation, if the doctor has been brought into the picture, has been brought on the scene by the patients themselves, then the institution will not be accountable for the acts done by such doctors. A very nice judgment, Rose judgment. These two judgments is something which you must read. With that, I come to an Indian judgment. And this particular judgment is my favorite, and I have always been saying that after a very long time, the Supreme Court of India has given something which is really a favor, really a boon to us medical practitioners. This is that famous Jacob Matthew versus the state of Punjab. This is that judgment, and I'll discuss this judgment. And then the fourth judgment that I want to discuss is a very bad judgment, something which I say is something which the Supreme Court should never have given. But we'll discuss it out. It's an academic meeting, so I can discuss it. See, I'm now on Jacob versus the state of Punjab. Here what happened was, by the way, before I start Jacob Matthew, a lot of people ask me, sir, I want to read medical law. Which is the book I must read? And to them, I've always been saying, you don't read any books with respect to medical law. If at all you really want to understand what medical law is, go to the net, on Google search, write down Jacob Matthew versus the state of Punjab, and you will get a 40-page judgment. This 40-page judgment, if at all you read, everything with respect to medical law is mentioned in that judgment. That judgment is so authentic. It is so beautifully written. I think even a lay person, if at all he reads it, he will come to know exactly what medical law is. This is the judgment that I'm going to now discuss. Now, in Jacob Matthew, what happened, I'll tell you. There was a patient who was an elderly patient who was suffering from terminal malignancy. The doctors told the relatives, you take the patient home and let the patient die at home amongst the relatives. No, we cannot do anything. But the patient's relatives were very influential. They said, sir, nothing doing. Let the patient stay in the hospital. Let the patient die in the hospital. Do whatever is possible for the patient. We know that the patient is going to die. One evening, what happened was, this particular patient suddenly started gasping. And when the patient started gasping, the relatives rang the bell, called the nurse. The nurse came, saw the patient gasping. She went back. She brought an oxygen cylinder and sent a call to the doctor. And then she started the oxygen cylinder, and this problem always takes place. When you start the oxygen cylinder, you find that the oxygen cylinder is empty. And that is exactly what happened in this case. Oxygen cylinder started, oxygen cylinder was empty. What the nurse did was, she kept that empty cylinder there, ran out again, and got a fresh oxygen cylinder. By that time, Dr. Jacob Matthew also came to the room, but then it was too late, the patient had died. This was the case. When the patient died, the relatives created a hangama in the hospital. Everything started. They went to the extent of going to the police station and lodging a criminal complaint against the doctors and the hospital. They said, well, my patient died because there was no oxygen, and my patient died because Dr. Jacob Matthew didn't come in time. All kinds of things are subsequently, all kinds of allegations are made, and that is the allegation these people made. The police lodged their FIR, and police started investigation, and after investigations, the police filed a complaint before the magistrate. Before the magistrate, Dr. Jacob Matthew and the other people who were involved said, what is it that we have done criminally wrong to be dragged into a criminal court for this particular problem that took place? Had the patient been at home, there would have been no oxygen cylinder, there would have been no Dr. Jacob Matthew, there would have been no nurse, and the patient still would have died. So what is it that we have done criminally wrong so as to be dragged to the criminal court for this particular problem that is taken place? So please quash the proceedings, close the proceedings. But somehow the magistrate said nothing doing, and he said that we will continue the proceedings. The moment this kind of an order was made by the magistrate, Dr. Jacob Matthew and others went to the sessions and asked for quashing the proceedings. The sessions court said nothing doing. They went to the High Court. The High Court said, nothing doing, let the trial run. And on this limited issue, Dr. Jacob Matthew and others went to the Supreme Court. And a very beautiful judgment Supreme Court gave. And this was a 3-judge bench judgment presided over by the Chief Justice of India, Justice Lahoti. And it was Justice Lahoti who has penned the judgment. And that is why this particular judgment has it has a lot of importance, because it is the Chief Justice of India who has written this judgment. You know what Justice Lahoti said? After a very long time, a very nice judgment was given. And Justice Lahoti said that for anything and everything that goes wrong at the hands of a medical practitioner, when he is practicing medicine, the criminal machinery must not be moved. If at all you want to, you stop me when you want. Huh? Because if these talks keep on going, So please, you're free. Just give me an idea about 10 minutes before. So Justice Lahoti said, for anything and everything that goes wrong at the hands of a medical practitioner while she is practicing medicine, the criminal machinery must not be moved. You can move any other machineries, you can go to any other courts that you want. Now, what are the other courts that a person can go to? The person can go to the criminal court, one, as it happened in Jacob Matthew. The person can go to the consumer court, which is known as the civil court, and ask for compensation. The person can again go to the medical council and ask the medical council to cancel the registration of this particular doctor. And there's another 4th place where the person can go, and that is the Human Rights Commission. If at all the hospital belongs to the government or any authority that is run on public funds, the person can also be sued before the Human Rights Commission. So the person can go there also. So in this judgment, the Supreme Court said that for anything and everything that goes wrong at the hands of a medical practitioner, then the criminal machinery must not be moved, but you can always go to a civil authority and ask for compensation. In short, what it meant to say was, if something goes wrong at the hands of a medical practitioner whilst he's practicing medicine, you should not think in terms of imprisoning the doctor, because the end result of criminal litigation is going to be imprisonment. So moving the courts with an idea of imprisoning the doctors is not correct, but you can always ask for compensation. Now, once I say this, you are all intelligent people. You will be thinking, then why is it that even today there is a complaint filed against a medical practitioner, the police calls the medical practitioner, and the matter is still placed before the magistrate, and the proceedings continue? Why is it that so happens, in spite of the fact that the Supreme Court has settled the law in this? One question comes up, and the answer to this question is very simple. The answer is, if you read the Jacob Matthew judgment, Jacob Matthew does not give you a blanket immunity vis-a-vis criminal litigation. I repeat, Jacob Matthew judgment does not give the doctor a blanket immunity vis-a-vis criminal litigation. Jacob Matthew says that if at all the doctor has done something which is grossly negligent or grossly reckless, if the doctor has been grossly negligent or grossly reckless, then the criminal machinery can be moved against the doctor. So what do you mean by this gross recklessness or gross negligence? I'll give you a very simple example. Dr. Shenoy, me, I'm a gynecologist. I deal with the pelvis. I deal with the organs there in the pelvis. Suppose tomorrow I say, I'm such a good surgeon, and I open up somebody's skull, and I do a craniotomy, and I manage a cerebral tumor. Suppose I do that, and in the process the patient dies. Now a gynecologist doing a craniotomy is an act which the law deems to be an act of gross negligence or gross recklessness. If such a thing happens, then the criminal litigation can be initiated against me. I'll give you another example. Dr. Shenoy is dead drunk. I can't walk straight. I'm just walking like this. And I enter into the operation theater and I do a laparoscopy. And in the process, I put the trocar cannula right into the aorta. And when I remove it, blood gushes out and the patient just cannot be saved. Patient dies on the table. Now, this particular act of Dr. Shenoy, who is dead drunk, who just can't walk, and I do a laparoscopy and I hit the aorta, this is an act of gross recklessness or gross negligence. In short, gross recklessness or gross negligence means an act done by a person who in his wildest of dreams or wildest of imaginations would not have done. A gynecologist in his wildest of dreams or wildest of imaginations will never do a craniotomy. And if I do that craniotomy, I am doing something which is grossly reckless or grossly negligent. Only in such circumstances can the criminal machinery be moved against me. Therefore, When the police files a complaint today, post Jacob Matthew, when the police files a complaint in the criminal court and asks me to initiate action and asks the judges to initiate action, what is it that the judges are expected to do? Judges are expected to first prima facie find out whether there is gross negligence or gross recklessness on my part. If the judges find out that there is no gross negligence and no gross recklessness, then the judges give back the matter to the parties and ask them, you are not expected to move the criminal machinery, but go to the consumer court or go to any other civil authority and ask for justice. And it is because of this that even today, post Jacob Matthew versus the state of Punjab, people still file a police complaint and the police still investigate. That is one. Now, Jacob Matthew is very important for another very nice thing that the Supreme Court has laid down. Supreme Court in this particular Jacob Matthew case says that if at all the doctor has practiced the way his peers expect him to practice, or if at all the doctor has practiced the way the textbooks expect him to practice, then whatever may be the end result, this end result in the eyes of law is not negligence. Once again, I'm saying, whenever I put a legal proposition, this legal proposition is very difficult to understand. I'll explain this particular legal proposition by a case law which has actually taken place. There was a patient who had delivered a child, beautiful, very happy, but then within 3 months, she got pregnant again. And she said that this is an unwanted pregnancy. So she went to her gynecologist. The gynecologist examined her, identified that she was pregnant, got her urine done, got her blood group done, got her hemoglobin done, and subsequently called her on the table, took her on the table and did a MTP. While the MTP was being done, the gynecologist identified that this particular pregnancy was not an intrauterine pregnancy, but it was a cervical pregnancy. Now see, cervical pregnancies are very dangerous, ladies and gentlemen, because there is no myometrium which contracts and causes stricture with respect to the blood vessels. That kind of a myometrium is not there in the cervix. When the sinuses are opened up in the cervix, they bleed to such an extent and many times it becomes difficult to control them, and that is exactly what happened in this particular case. Well, she was bleeding like mad. They gave her blood, nothing happened, and finally they had to open her up and do a hysterectomy. Well, hysterectomy was done. First 3 months went off very well because the patients make the best of you. They don't say a word until the entire treatment is over. And once entire treatment is over, then they flex their muscles. And that is exactly what happened in this case also. Then this particular gynecologist received a legal notice. And the legal notice said that my client has only one female child. She wanted to have a male child, and now the male child is impossible because you have removed the uterus. Now it is impossible that my client will go to heaven, because to go to heaven, you need a male child to light the fire. Na? Correct? Na? Huh? So you pay me compensation now. And the negligence that what was impugned in this particular case was, you did not do a sonography prior to doing a MTP, because had you done a sonography, this particular cervical pregnancy would have been identified, and we could have then taken necessary steps well in advance, and then we could have taken a decision whether to go ahead or what is to be done. You did not do a sonography prior to MTP, and that is why this particular problem took place. That was a case that was put up in the courts. Now what the gynecologist did, gynecologist said in the reply, he said that, well, a routine sonography prior to MTP, a normal MTP, is never done by anybody. Only in selected cases we do a sonography. Otherwise, a routine ultrasonography prior to MTP is never done. And when he made this statement, he authenticated this statement by keeping 3 standard textbooks before the court. And all the 3 standard textbooks that he kept before the court did not say that ultrasonography was mandatory prior to a medical termination of pregnancy. The court read it, the court was convinced, and the court said that this particular gynecologist has practiced the way his peers recommended him, or this particular gynecologist has practiced the way the textbooks recommend him to practice, and therefore, whatever may be the end result, this end result in the eyes of law does not mean that there is negligence on the part of the doctor, and the doctor was released, not a single rupee was paid as compensation. So, coming back to Jacob Matthew says that if at all you have practiced medicine the way your peers recommend you to practice, whatever may be the end result, that end result in the eyes of law is not negligence. Such a bold statement it has made. Therefore, the question is, how is it that you prove to the court that what you have done is as per standard treatment protocols. How do you prove that to the court is the question. And this is what I'm going to tell you all. Very important when it comes to actually practicing medical law. The first way in which you can prove to the court that what you have done is what is recommended by the peers is you place the standard textbooks in front of the court, like what was done in this MTP case. Suppose the textbook is silent on a particular point, then how is it that you can prove yourself in the court of law? You can always keep peer-reviewed journals in the court of law. You know, articles in peer-reviewed journals are as good as articles from textbooks. Suppose the journal is also silent on a particular point that you are making, then how is it that you can prove to the court? Then you can take expert opinions from seniors in the profession. You know, some senior gynecologist or some senior ophthalmic surgeon or some senior anesthesiologist, you can take their opinion and place it before the court. And the senior person says that this is a standard that is adopted by the fraternity, and if at all the doctor has practiced that way, he has done nothing wrong. Suppose nobody comes forward to give an opinion, then what you can do is, this is something very dangerous, what just now I'm going to tell you all. You can always ask the court, make an application to the court, and ask the court to send the papers to one of the teaching hospitals and take an opinion from them. Now, mind you, if people in the teaching hospitals are good, they will give a true opinion. Otherwise, there are some problems there, which I don't want to discuss because I am being recorded. That is the problem. Now, suppose teaching hospitals there are no teaching hospitals in that particular district. Then what do? Then what you can do is, you can rely upon internet. Now there's a lot of trash on the internet. A lot of rubbish is there on the internet. Therefore, only peer-reviewed sites that are there on the internet, like PubMed, etc., peer-reviewed sites are accepted by the courts as evidence to prove to the court that whatever you have done is as per standard teaching protocols. So this is very important. This is what Jacob Matthew has laid down. Jacob Matthew has laid down another very important thing. And that another very important thing is how a doctor is to be arrested. Now see, what we people are most worried about. See, any case of medical negligence can be agitated before the criminal court, can also be agitated before the consumer court. Any case of medical negligence. Now, we people are bothered about criminal litigation because the end result of criminal litigation is going to be imprisonment of the doctor, and no doctor wants to be put behind bars. We are very much worried about it. The second reason why we are very much worried about criminal litigation is because if the criminal court convicts you and imprisons you even for 1 day, then the medical council all by itself can deregister you. That provision is there in the Code of Medical Ethics. That is why we people are very much worried about the criminal litigation. We are not worried about the civil litigation because the end result of civil litigation is payment of compensation, and most of us are insured. The insurance company will back you up, so we are not bothered about it. But criminal litigation, we are bothered. Once upon a time, prior to Jacob Matthew, most of we doctors were very much worried with respect to being called by the police because we felt, and it usually used to happen, it actually happened, that the police used to call you for recording your statement, and once you are in the police station, the police used to arrest you and they never allowed you to go back home. This was a very routine practice that was there prior to Jacob Matthew. But if you read Jacob Matthew, the Supreme Court has been very kind to lay down the way in which a doctor is to be arrested. And this is what the Supreme Court says. The Supreme Court says that if at all there is an FIR filed against a doctor, if at all there is a complaint filed against a doctor, and the police cannot directly arrest the doctor once the complaint is filed, but the police is supposed to follow this particular protocol. The police is supposed to investigate. The doctor is called, his statement is taken, the nurses are called, the ward boys are called, the other doctors are called, the anesthetist is called, and everybody's statement is recorded. The indoor case papers are also collected by the police. And then the police makes a file. The police is supposed to send this file to one of the teaching hospitals. So this is what Jacob Matthew says. The Supreme Court in Jacob Matthew says this. The police is supposed to send this file to one of the teaching hospitals, and the dean or the medical superintendent of that teaching hospital then formulates a committee, and this committee goes through the file and gives a prima facie opinion. And once the prima facie opinion given by such a committee says that there is prima facie negligence on the part of the doctor, only then the police can make the relevant section of the Indian Penal Code applicable and arrest the doctor. Conversely, if this particular